Good afternoon, everybody. It's a pleasure to be back with you. It's February 7th, and here in New York City, where I'm speaking with you from, it is starting to warm up quite a bit, at least relative to that really brutal cold snap that we all endured. And I'm hopeful that you enjoyed the relatively warmer back end of the weekend that followed for most of us in the Northeast. For those of us tuning in across the geography where Bond has offices, we're glad that you can be with us, whether Florida, Kansas, or nearby. And let me walk you through the agenda for today. We've got a full program, and I think that by way of what I can walk you through right now, you'll get a better sense of what we intend to cover. Let me start with what I'm going to tackle. First, it'll be what we know about public health and the PHE, which of course you heard from Adam last week is going to wind up on the 11th of May, but let's talk a little bit more about what that really means. I'll also address the budget as proposed by Governor Hochul here in New York State. Joanna Silver, an attorney based in our Westchester office, and who is a part of our immigration practice, will be addressing the H-1B visa cap season. Important to be aware of that for those of you in that space. Mario Abrub is back with us, and Mario will be covering the Children's Online Privacy Protection Act, Mario from Buffalo. And then Kat Grazios out of our Albany office is also back on the program, and she'll address a proposed rule out of the federal government concerning HIPAA privacy standards. And I will then make sure that we have a few moments to answer your questions as they happen. And so thank you in advance. And Kathy, if you go to the next slide, we can walk through the material for today. So to begin, as I mentioned, the public health emergency is going to be ending on May 11th. That's going to have numerous implications, and we're still candidly figuring out what some of those are, and we'll be back with you in a regular way to make sure we're keeping all of you up to date as it relates to your businesses. But we know that COVID tests and vaccines are not going to be as readily available or otherwise paid for as they were, depending on insurances, and cost sharing is going to become a much more regular part of what it is to live with COVID on an ongoing basis. Here in New York City, there are vans all over the place where one can get a nasal swab and a test, and I expect that those types of facilities, as they are mobile facilities, are going to be changing the way they do business, the volume they do business, because all of that is tied to the public health emergency. COVID treatments, as we have seen in these last few months, there are some really effective ones, but in terms of how they're paid for, that is also going to change as the federal stockpiles diminish in the context of the emergency's wind down. Hospitals aren't going to be receiving a 20% bump for those whom they care via the Medicare program, who are coping with COVID symptoms. Data privacy, we're going to see some changes. Kat will, of course, be touching on some data privacy issues later today, but with specificity around the public health emergency, there are going to be some tightenings we expect around HIPAA enforcement, where we had seen some relaxation going back to early 20. And then on telehealth, we've talked about this a bit before, but while in the Medicare program, through separate legislation that President Biden signed into law, essentially Medicare will be covered through 2024 by and large, as we've been experiencing it through the public health emergency. With other payers, it's a little murkier, and we're still figuring that out. With mental health services, though, as I signaled in my previous presentation about what's ahead in 23, 2 weeks ago, I think in mental health, we'll by and large see a steady state because it's been appreciated that telehealth has been a real game changer. Next page, please. Thank you. And then all of this comes in a federal context where President Biden will be delivering the State of the Union. And it's, of course, in a backdrop where the president is expected to announce a run for re-election imminently, although that hasn't been official as of yet. We know that there's a major set of changes in terms of the House leadership and with Speaker Pelosi stepping down and McCarthy stepping up. And we know that has had a relationship to committee assignments and the work that is done in the House on a going forward basis. And so all of that is the room into which the president will be stepping later this evening. And I expect, as do many prognosticating, that the president will touch on certainly the public health emergency, and maybe there'll be some more details revealed there. There's plenty happening, of course, in international domains that we can expect will be on the agenda this evening. And then climate, gun violence, and public safety and economic issues. And if there's anything that comes out of that speech that we think is really important for all of you to know, we'll make sure to report back. Next slide, please. And here in New York City, it's also important to recognize that in this changing context of what the pandemic is versus what it was and how we're learning to live with it, Mayor Eric Adams has opted to, on the assumption that the Board of Health approves it later this week, end the vaccine mandate that's been applied to municipal employees. This has been a very controversial policy in many respects. There are a number of individuals who have been working for city government who were not allowed to continue because they chose not to comply with the policy. They won't be immediately reinstated, but they'll be able to reapply for jobs. Overall, Mayor Adams is attributing the change in policy to one of timing as much as anything. The COVID numbers are in much better control than they had been. For those of you who tuned in last week while Adam was hosting, you saw that the map of New York State in particular looks pretty calm relative to where it's been, and certainly this time last year. So thank goodness for that. And what I can also remind you about is that there's a context here because while yes, we're moving to a new stage of the pandemic, some of the pandemic related changes, particularly around hybrid work, seem to be here to stay. And so the mayor had been very steadfast on the fact that city employees, as much anything, means of providing an example to the rest of the workforce here in the downstate, should be returning to their offices 5 days a week. Seems like there'll be some relenting on that policy based on some of what's been rumored recently. So we'll see, and we'll keep track as that relates to choices that all of you might make for your businesses, whether here in this downstate or elsewhere where you be tuning in from today. Next slide, please. And so also on public health, let me just quickly highlight that we've talked about monkeypox, mpox, as it was reframed over the course of late last year. That by and large is behind us, it seems. Here in New York, there is no more spread in the community at any measurable level. And so DOHMH has officially declared monkeypox as no longer a public health threat or in an outbreak status. So next slide, please. I'll shift to a quick rundown of what we'll be tracking on the budget. And the governor, of course, released budget proposals, as Governor Hochul, earlier this month on February 1st. And with Medicaid, this is, of course, central to so much of what the public health emergency has been about, whether in New York or otherwise. And there's been a very regular conversation about whether the Medicaid system is sufficiently compensating providers to do their work. And the governor has proposed a 5% increase for a variety of providers, including hospitals and nursing homes and assisted living providers. There is concern being voiced by those same providers who would be in receipt of these increases that it's still not enough. So we shall see. This will certainly be debated territory over the course of the coming weeks, whether through the 30-day amendments the governor will be presumably issuing, and then the one House bills that the Assembly and the Senate will themselves be issuing, all to get to a budget agreement on April 1st. But the governor also has proposed about $1 billion of investment in mental health, a minimum wage indexing to inflation as a means of continuing to elevate it in a predictable fashion. Other focal areas are listed on the bottom left of the slide here, including like what we expect the president to touch on, gun violence. There's public transit investments, jobs, climate, and we also expect that over these coming weeks here in New York, we'll be debating any number of these issues and others that may emerge. So As is our commitment to you, we'll keep you up to date on the legislative activity that matters to all of you and the various programs that come out of the budget once that handshake happens on or about April 1st. So with that, let me turn to our next presenter, and I thank you all for staying with us. We're delighted to have Joanna Silver. Joanna is based in our Westchester office. Joanna is a member of the firm and has a focus on both education and immigration in her practice. We're delighted that Joanna can be here to walk us through H-1B visa cap season. Who knew that there is a season, but evidently there is, and it's time to really pay close heed to what that means for those of you who are employers who seek to bring in individuals from other countries who can provide service to your industries. So I will turn it over to Joanna. Thank you so much for taking the time. And Joanna, the floor is yours.
Great. Thank you, Gabe. Hi, everybody. Happy to be with you today. Yes, so as Gabe mentioned, my presentation today is getting ready for H-1B visa cap season. And it is the most wonderful time of the year for immigration attorneys. This happens to be a very busy time of year for immigration attorneys, as well as employers who are seeking H-1B visas for their international employees. Next slide, Kathy. So before I get into the cap itself, for those of you who aren't familiar with H-1B visas, they are the #1 vehicle for employers looking to bring professionals to work in the United States. The H-1B visa is available for those professions that require at least a bachelor's degree in order to enter that profession. And the individuals who are in those positions must have a degree in the area of expertise in order to be eligible for an H-1B visa. So for instance, if somebody is an accountant, they would have to have at least a bachelor's degree or higher, depending on the employer's requirements in accounting or a similar area. So what happens is each year on October 1st, which is the start of the USCIS, U.S. Citizenship and Immigration Services fiscal year, the amount of H-1B visas available for the taking replenishes. The reason why it's October 1st is that is the start of the fiscal year for the Immigration Service. It runs from October 1st until September 30th. And what are we dealing with? What are we vying for here in terms of the visas that employers are seeking for their international employees? It's actually a pretty small bucket, and you'll see that later on when I get into how many registrations are actually filed for the number of visas. We're talking about 65,000 base visas available in the H-1B visa category. And there's actually a 6,800 set aside specifically for people from Chile and Singapore for H-1B1 status, which is a treaty exception. So we're really talking about a little less than 65,000 available visas in the basic cap. And then there's an additional 20,000 visas available to individuals who have earned a master's degree or higher from a U.S. institution of higher education. And this was added to the law a few years ago. It's a nice little benefit for individuals who have been here and studied and earned their higher degree here in the United States. So we're talking about 85,000 potential visas available during the next fiscal year. Now, not every H-1B visa application is included as part of the cap filing season. I do a lot of work for institutions of higher education, and all jobs at institutions of higher education are excluded from the cap, which is fantastic. So I get to do, in addition to being busy during H-1B visa cap season, I'm able to do H-1B visa petitions for my higher education clients all year long. There's no restriction on that as long as it's a position at an institution of higher education or their related or affiliated entities. There are other items that are not included in the cap, including if you're doing an H-1B visa extension, if you're filing an amended petition, and there's a few other exemptions depending upon the facts and circumstances of each case. But essentially, a lot of people, a lot of possible potential employment relationships with international individuals are going to be included in the annual H-1B visa cap. So for instance, if you've got somebody who lives overseas who would like to come and work in the United States and is getting an H-1B visa for the first time, they would be included in the cap. If you've got somebody on your staff who is an F1 student who's currently working for you on what's called optional practical training or OPT, and that's running out and they're going to need an H-1B visa and are changing their status from F1 to H-1B, they're going to be included in the cap as well. Next slide, Kathy. So we're going to talk a little bit about how this process starts. And there's a fairly new process that requires employers to register in order to participate in the annual H-1B visa cap lottery. For those of you who are on this call who've been dealing with this for many years, you'll remember that prior to a couple of years ago, this entire season was performed a little bit differently. You used to look and see who on your workforce would need H-1B visa sponsorship. And then you would probably send your items to us, or if you were using other counsel for this, to prepare full petitions on behalf of your employees. Those petitions were filed with the Immigration Service on April 1st, which was the day that you could first file 6 months in advance of the October 1 start of the fiscal year. And you would hope that your petition might be selected for processing. And if it wasn't, it would be returned to you. So I can remember those days filing, preparing, doing all the work on the front end, filing the petitions, and then getting a whole bunch of packages back once the annual cap was reached and my petitions were not selected for processing. So I have to say, I don't compliment the Immigration Service that often, but a few years ago, they designed this relatively new system that requires employers to register in order to be selected to first file an H-1B visa petition on behalf of their employees. So now we deal with a registration process and hopeful selection. If you're selected during the registration process, then you can file an H-1B visa petition. So the thing is, it's still very challenging to get an H-1B visa annually. As you can see, during the first fiscal year that this new system was in place, for the 85,000 visas, there was 275,000 registrants, and that has only gone up. Last year was kind of the first quasi post-pandemic year, and people were coming back to work and what have you. So it really exploded through the roof. And as you can see, there was almost 500,000 registrations for 85,000 potential visas. So it's still a struggle to get a visa, but at least you don't have to go through the entire process of preparing all these petitions and filing them only to find out that you weren't selected. We don't yet know what's going to happen this fiscal year. There are some thoughts that there might be a decrease due to some of the financial issues going on in the tech industry, where a lot of H-1B visas are used, and also because of recession and various layoffs in industries. So unfortunately, we won't know for quite some time how many people are going to register for this season. So we'll have that information for you at a later date. Next slide, please. So how does this work? The registration period is only open for a very limited time. It opens noon on Wednesday, March 1st. It closes at noon on Friday, March 17th. Prior to registering various cases to be selected potentially for H-1B visas, employers and their lawyers, if they are using them, have to set up a My USCIS account in order to be able to file these registrations come March 1st. I provided the link there for you in case you need to set up this account. You could start doing this as early as noon on February 21st, but at that time, you're not going to be entering any employee information or submitting any registrations. That's going to come later on March 1st. All you're doing at this point is creating an account for yourself, and your lawyer would be creating an account as well. Once the account is created, it can be used each year. So once this is done, you're set for the immediate future until the process changes somewhere along the lines. For each registration that you do, so let's say you have 20 employees that you want to seek H-1B visas for, it's $10 per registration. So you'd have to pay $200 for those 20 registrations for those 20 petitions. There is a little controversy over this. It's surprising that the fee is so low, and a lot of people feel because it's so low, that's why so many people register, that if it were a little bit higher, maybe employers would think before filing and not flood the system. So there was some discussion about raising the registration fee, but for now, just to register to be selected in the lottery is $10 per employment petition. And like I said, it can be submitted from multiple employees. Now, if they don't receive enough registrations by the close of the registration period, if they do receive enough, meaning more than 85,000 registrations, what they're going to do is randomly select the registrations and notify those employers who have been selected for processing their petitions. And this is all done through the My USCIS accounts. They're aiming to notify everybody by March 31st, but usually they're a little late on that. So that's the date that they're targeting. Now, if they don't receive enough registrations, which would be a complete miracle, then all those individuals would be notified about when they can start filing the actual petitions to obtain the H-1B visa. And normally that notification, as I said, will come through the My USCIS accounts, and you're generally given 90 days in which to submit an H-1B visa petition on behalf of the employee who was selected as part of the lottery. So the person, when you're selected during the lottery, the person doesn't get an H-1B visa. They only get the right for the employer to file an H-1B visa petition on their behalf. And their H-1B visa status would start, if it's approved, on October 1st, the start of the fiscal year. I have a note down here about multiple lottery selections. Sometimes if they do an initial selection, and if for some reason some of those selected have either moved on to other jobs or decided they don't need an H or something like that, they might do additional selections. They did that a couple of years ago. I think last year there weren't additional selections. So it really turns on the pool of applicants that they get during the registration process. Next slide, please. So what should you be doing now to get ready for this? Basically, what you want to do is you want to have a good look. HR should have a good look at the workforce to determine who's going to need an H-1B visa come October 1st, 2023. Very often, I get calls over the summer about somebody needing an H-1B visa, and I often have to tell them it's too late. If you wanted an H-1B visa for this year, we had to be talking back in February, getting you registered in March, hoping that you get selected, and then filing a petition in April or May of this year. When you're shut out, you don't get to do it again until the following year. So it's really worth the time to go through the workforce, see if there are people whose work authorization is expiring, or who needs to be petitioned for. So for instance, we talked about, you might have people working for you as an F1 student who's on OPT, and the OPT is expiring on, let's say, October 11th. So after October 11th, if the person doesn't have an H-1B visa, they're not going to be able to continue working for you. So those are prime candidates to be registered for H-1B visa registration. Also, you might have some H-4 or L-2 dependents who want their own work authorization or work visa separate and apart from what they get as a result of the relationship with their spouse. Also, TN workers who are Canadians or Mexicans who are thinking about starting the green card process, because being an H-1B is a little bit more appealing when you're going through the green card process, because you're able to maintain your work authorization and travel privileges through the H-1B while you're pursuing the green card process. And then, of course, what we talked about before, new international workers who are located outside the US who don't have any immigration status. That there are probably some more exceptions or more examples of people who would need to be registered, but these are the ones that we see most frequently. Next slide, please. That's it. I'm done. So good luck, everybody. As the saying goes, you got to be in it to win it. If you have any questions about the registration process or H-1Bs, we are here and happy to help at any time. Thanks so much and have a great day.
Joanna, thank you. That was really informative. And I know much more about that season than I did beforehand. So thank you for bringing that information to the group here. And we're now going to switch gears and bring Mario Ayub back onto the program. Mario has been with us before and focuses on intellectual property matters out of our Buffalo office. And we're going to learn more about privacy violations in connection with Fortnite, which certainly has a variety of implications for kids, for families, and for the meanings around government regulation and government intervention. So, Mario, looking forward to learning with you, and please bring us up to speed. Thank you. The floor is yours.
Thanks, Gabe. Thanks for having me back. It's good to be back on the program, and thank you to everybody listening in now. Thanks for spending your lunch hour with us. So I'm going to talk a little bit about this recent FTC settlement with Epic Games, the developer of Fortnite. And although this settlement is focused on video game as the product, the takeaways here are widely applicable to anyone who runs a publicly facing website or offers a software as a service. It's just a great fact pattern to kind of explore how the FTC is approaching these types of issues. If you could please move to the next slide. So just a little bit of a background on Fortnite. I'm sure the vast majority of people in this webinar know what it is. If you have kids, they definitely know what it is, but it is a free-to-play game that was launched in 2017. It has an enormous user base, and even coming out in 2017, the user base continues to grow. It's over 400 million registered users and counting, and it's a huge profit generation mechanism for Epic Games, despite being completely free to play. Over $5 billion in revenue in 2021. Years past have been very consistent around that $5 billion revenue mark. So it's a huge, huge enterprise. But it's also important to note that all the purchases made in the game, it doesn't offer any competitive advantage. It doesn't offer anything to help you win. It's purely cosmetic items to customize your character, to customize the tools that you use in your game, completely optional. You could be the best in the world and not spend $1, but we have over $5 billion annually. So that's just a little bit of background on how widespread this game is and how profitable it is. If you could please move to the next slide. So the FTC's allegations here were separated into two separate complaints. The first was focused mostly on the privacy violations. We're going to touch on both. But the first thing in the privacy complaint was a COPPA violation. We're going to get into what COPPA is, what that entails. But basically, it was a failure by Epic to obtain consent from parents and guardians before collecting children's data. And then also the always-on voice and text chat was found to be harmful to minors, allowed access to adults communicating with children without any controls in place to really check that. The second complaint was more about the marketing practices of Epic and Fortnite, specifically these techniques called dark patterns, which we will get into in a little bit. But essentially here, the claim is that Epic used these dark patterns to trick users into making purchases. Epic did not continue to ask for consent to reauthorize cards. So if a parent made a purchase one time for a child, they were unaware that their child could continue to authorize their credit card to make purchases. There's a decent chance that someone in the seminar has run into a circumstance like this when they look at their bill from either the App Store or other online service and find some charges from their kids. That was a focus here. And then they also blocked access to content that users had already purchased. And that was a major red flag for the FTC. So two separate complaints. We're going to get into them in a little bit more detail now. Next slide, please. So what is COPPA? COPPA stands for the Children's Online Privacy Protection Act. It imposes certain requirements on operators of websites or online services that are directed to children under the age of 13, or these services or websites that have actual knowledge that they are collecting information from children under the 13. So basically, you could fall into either one of these buckets here, and you're under the jurisdiction of COPPA. COPPA requires website operators to fully disclose what information that they intend to collect about children on the website or on the service that you're using, so that a parent or guardian can make an informed decision and they can obtain consent from the parent that it's okay to start collecting children's data. That has to happen before any collection happens. And this is the particular provision that's at issue in this settlement agreement. Next slide, please. So the main inquiry here for the FTC, looking at potential COPPA violations, was Fortnite marketed toward children? So the FTC engaged in a very detailed fact-based inquiry, and they consider several things. First, you got to look to the multiple licensing and business deals that Epic was entering into with very popular brands. You see Star Wars, the NFL, Marvel, musical artists that are popular with children. And there was a retail deal with Spirit Halloween, which does a lot of children's costumes. So they were able to point to a lot of business initiatives suggesting that this is where they were targeting their market. Epic also routinely conducted market research on their demographics. So that's the actual knowledge piece. They knew who their target audience was. One fact that stood out to me when reading the settlement was about 53% of US children between the ages of 8 and 12 log into Fortnite once a week. That's just an enormous amount of the player base that falls directly under COPPA's jurisdiction, and Epic was very well aware of that. And finally, internal employee communications. So there were a lot of messages uncovered where developers planning new updates were saying, the litmus is, will this appeal to a 12-year-old or a 13-year-old child? That's the type of content we want to continue to bring. So a very fact-based inquiry. Next slide, please. And then also with the privacy complaint, this voice and text chat, FTC found many violations of privacy controls where adults and children were able to communicate with unfettered access. They noted some instances of cyberbullying, exposure to sensitive content, and Epic did eventually add chat controls before this action was brought, before this complaint was brought. However, the FTC didn't really give it a lot of weight because it was buried in the settings. Gamers couldn't find it, the parents couldn't find it, more importantly. And so effectively, although the controls were technically there, they weren't easy to find. So that's another compliance tip that's worth keeping in mind. Even if you have the proper security controls in place, they have to be accessible. They have to be ready to use, otherwise they're not meaningful. Next slide, please. So the dark patterns complaint, the separate complaint brought at the same time. So essentially, dark patterns are these interfaces designed to trick a user into doing things that the user does not intend. You see this a lot with mobile applications, a lot of free games on your iPhone. You have to convert currency to their in-game currency. You lose track of what you're spending. It's too easy to make purchases. The buttons are large. It runs the gamut, really, of what could fall under this dark pattern characterization. So the FTC alleged that Fortnite's menu encouraged accidental purchases. They found that people were making purchases when the game was loading, when it was in sleep mode, which is obviously a problem. They didn't know they were making these purchases, and the game wasn't even showing the purchases. As I alluded to earlier, the continual authorization of a credit card without any check or verification that the card should be authorized again, no notice that the card would continue to be on file, and then of course removing access to items that were already purchased. So that's the look at both complaints and what the FTC found. If you want to move to the next slide, please. So when looking at this and trying to extract some lessons learned and stuff that could apply to your organization, your business, it's important to acknowledge FTC's growing role in regulating privacy and data security. Of course, their primary legal authority comes from Section 5 of the FTC Act, unfair and deceptive trade practices. That is a very, very broad and powerful tool for the agency to use to regulate a wide variety of different business sectors. And it's quite a flexible tool for a lot of different violations, anything that's unfair or deceptive in the marketplace. But they also have sector-specific jurisdiction with COPPA, for example, what we're talking about today, and other sector-specific laws. In last year, in August, the FTC published an advance notice of proposed rulemaking where they widely publicized that the agency is looking to take on a larger role in regulating privacy, particularly in the space of children's privacy, automated decision-making, how to develop and improve informed consent and notice mechanisms, and whether or not new rules were needed to kind of fill in the gaps where Section 5 doesn't necessarily fit. They acknowledge a growing role, a growing need for regulation to catch up to the speed of technology and the changes that we've seen in the last few years. So we expect after the comments are reviewed, a more formal rulemaking process will likely commence. We will keep a track of that, but would not be surprised to see some new regulations coming forward, or FTC bringing in different agencies to help promulgate new regulations. So the overall theme here is the federal government is really starting to pay close attention to these privacy violations. You typically see a lot of enforcement at the state level with state privacy laws. FTC is starting to take the lead here on federal privacy in the consumer context. So if the next slide, please. So finally, a few key takeaways that are worth remembering. Again, this was about video games. This was about an entertainment product, but it really does apply broadly. So evaluate whether your organization's customer base and determine whether your organization's website markets towards children. So really look at the mechanisms. What is the website showing? Are there bright colors? Do you utilize branding that is familiar to children? It doesn't necessarily have to be purposely marketed towards children, but if there's anything that on there that would make a child sign up on the website or try to access a service, you have to really evaluate your website honestly and determine whether this is something that the FTC could look at. For example, disclaimers are not enough, and that's very similar to my first point, which is a lot of privacy policies, a lot of privacy statements. They say we don't market to children, but here we saw the FTC looked past any representations and looked exactly at the actions that Epic was making, pretty much disregarding any statements to the contrary. So I'll wrap this up because I see Dave is back online. Listen to your employees. One of the smoking guns for the always on communication was employees had recognized this as a privacy issue and brought it to Epic's attention early on. Those went ignored. Listen to your employees. It's free information. They're the closest to your product, and they know it better than anybody. And evaluate your website's interface regularly. How easy is it to make a purchase? Can the FTC or another regulatory agency characterize anything on there that looks like it could be employing dark patterns? And just keeping track of that as your website and service changes. So I'm going to wrap up now since we're running out of time. If you have any questions, please drop them in the chat or email me afterwards. Happy to have a larger discussion beyond any of these themes.
Mario, thank you so much. We're thrilled that you came back, and we look forward to hearing from you in the future, representing our cybersecurity and data privacy practice. And let me switch gears again, and we'll move to Albany, and in particular, Kat Grazios, who has been on our program a number of times before. Kat, thank you for returning. And Kat is here to tell us about a proposed rule by the Federal Department of Health and Human Services involving HIPAA privacy standards, really important terrain for those of you in the healthcare space. Kat, looking forward to learning. Please let us know what we should know. Thank you.
Thanks, Gabe. As Gabe mentioned, I'm Kat Grazios. I'm an associate here in Albany. I work in our higher education and our healthcare practices, and I'm going to speak a little bit to the recent notice of proposed rulemaking that looks to align Part 2 with HIPAA. The Department of Health and Human Services issued this proposed rule to streamline federal regulations governing confidentiality of substance use disorder records and bring it in line with HIPAA. Next slide, please. So you may be wondering, can you go to the previous slide, please? All right. Can you go to the next slide? We're missing a slide there. So if you can go back to the previous slide, I'll just go a little off script. So what is 42 CFR Part 2? This protects the confidentiality of substance use disorder treatment records, records created by a federally assisted program for the treatment of substance use disorders. So really, this protects any records of the identity, diagnosis, prognosis, or treatment of any patient which are maintained in connection with the performance of any program or activity relating to substance abuse education, prevention, training, treatment, rehabilitation, research, etc. So given that this applies strictly to substance use programs, etc., it's a little bit different from HIPAA. Next slide, or actually stay on the slide, please. So what exactly is HIPAA? HIPAA is a privacy rule established national standards to protect individuals' medical records and other individually identifiable health information. This is the Health Insurance Portability and Accountability Act. It's appropriate safeguards to protect privacy of PHI and set limits and conditions on the uses and disclosures that may be made of such information without an individual's authorization. This applies to health plans, healthcare clearinghouses, and those healthcare providers that conduct certain health transactions electronically. Appropriate safeguards to protect the privacy of PHI and set limits and conditions on the uses and disclosures that may be made of such information without an individual's authorization. And it creates individual rights over their PHI. So one has the right to examine, obtain copies of their PHI. One has the right to request records, direct their PHI to certain individuals, etc. Next slide, please. So recently, these notice of proposed rulemaking brought up the alignment of HIPAA with Part 2, because we're dealing with two different sets of protected health information here, one being for substance use records, one being for general health records. And so it would make sense to align the two privacy standards so that way they are the same, because right now they are not. So changes are intended to improve care coordination for patients and ensure individuals do not forgo life-saving care due to concerns about record disclosures. Right now, the theory is that under Part 2, based on the way that privacy protections are in place, some individuals may, out of fear of prosecution or fear of stigma associated with substance use disorder, may not seek treatment. And so the alignment is intended to further promote individuals wanting to go into treatment and be more open about substance use disorder. Next slide, please. So the CARES Act, where does the CARES Act come into play? Well, the CARES Act, which we know was the Coronavirus Act from 2020, actually promulgated revisions that necessitated the need to bring these two acts in accord with one another. So meaning that Section 3221 of the CARES Act required the Secretary of Health and Human Services to align certain aspects of Part 2 with HIPAA rules in the HITECH Act. So we've been waiting for nearly 3 years for these regulations to come about to align the two with one another. Next slide, please. So what has been proposed? Well, we've seen the single prior consent model. This would allow Part 2 programs to use and disclose Part 2 records based on a single prior consent signed by the patient for all future uses and disclosures for treatments, payment, and healthcare operations. Redisclosure of Part 2 records is allowed under HIPAA, meaning that permit the redisclosure of Part 2 records as permitted by a HIPAA privacy rule by recipients that are Part 2 programs, HIPAA covered entities, business associates, certain exceptions apply there. We're seeing the expansion of prohibitions on the use and disclosure of Part 2 records in different legal actions. That's what I was getting to earlier regarding the individuals engaging more with their doctors and professionals regarding their substance use disorder for, lack of fear of retaliation now. This creates two patient rights under Part 2 that align with the individual rights under HIPAA. So that's a right to an accounting of disclosures and a right to report restrictions or a right to request restrictions on disclosures for treatment, payment, or healthcare operations. Next slide, please. There's a number of other proposals being that required disclosures to the Secretary for Enforcement. Now we're seeing the application of HIPAA and HITECH Act civil and criminal penalties to Part 2 violations. We're seeing the requirement for Part 2 programs to establish a process to receive complaints of Part 2 violations, prohibition on Part 2 programs from taking adverse action against patients who file complaints, prohibition on Part 2 programs from requiring patients to waive their right to file a complaint as a condition of providing treatment, enrollment, payment, or eligibility services. And next slide, please. Finally, we have this applies to standards of the HITECH Act and HIPAA breach notification rule to breaches of Part 2 records under the Part 2 programs, aligns Part 2's patient notice and HIPAA notice of privacy practices with one another, modifies the HIPAA notice of privacy practices requirements for covered entities who receive or maintain Part 2 records to include a provision limiting redisclosure of Part 2 records for legal proceedings according to Part 2 standards. And finally, permits investigative agencies to apply for a court order to use or disclose Part 2 records after they unknowingly receive Part 2 records in the course of investigating or prosecuting Part 2 program. Yeah, that's all for me. So I wanted to thank Gabe for allowing me the opportunity to be on here, and thank you all for listening in.
Well, Kat, thank you for coming on. We really do appreciate that HIPAA relating update. It's a very complex web out there when it comes to health data, and the more we know, the more we'll share with all of you. I will be back with you in 2 weeks' time. Really glad that I could spend the lunch hour with you today, and we're hopeful that you'll tune in next week for more of Business in 23.